Okay, hello everyone, and welcome to our second installment of the Fair Housing Workshop for Landlords and Property Managers for 2022. Thank you so much for joining us today. We are extremely happy to have you. My name is Kimmy Johnson, and I am the Fair Housing Education and Outreach Coordinator with the Housing and Community Development Department. But I'm also the lead for programs like the Fair Housing Ambassador Program and the Fair Housing Hurricane Season Preparedness Outreach Program and workshops such as this one. And I must say that this is one of our favorite workshops, and we are extremely thrilled to bring this back again this year, especially as we close out Fair Housing Month. So you're going to be hearing from me a little later in the presentation, but now at this time, I would like to turn things over to my colleague, Ms. Kristen Robinson, who will be moderating today's presentation. Kristen?
Hello, everyone. And Kimmy, thank you for hosting these meetings. As she said, we're really excited to have you guys here. And happy Fair Housing Month to you all. Again, my name is Chris Robinson, and I'm a senior planner with the City of Houston's Housing and Community Development Department. Thank you all for joining us, along with our two special guests, as we discuss housing providers' responsibilities under local and federal fair housing law. But before we move along in the agenda, I do want to highlight a few things for you. One, we are recording this presentation, so we will post that video on the housing website in the next coming weeks. However, you will get an email for all of the workshop materials that are presented, and those will be sent to all of the registrants. So please check your email for that information later today. Also, your microphones are muted, but the chat is available to you. You can post questions there that you might have as we go along through this presentation, and we will try to answer those questions during the Q&A. And also, we will provide a certificate of attendance upon request. You will have to email us at fairhousing@houstontx.gov. So, as I stated earlier, we have two special guests with us. You will also hear from attorney Howard Bookstaff. He is the equity partner for Hoover Slovacek, and he heads the multifamily practice there. For over 25 years, he has focused on commercial and residential real estate, landlord tenant law, condominium law, and community association law. Mr. Bookstaff has also served as a general counsel for the Houston Apartment Association since 1995, and he's often representing clients that own and manage real estate properties. He's also a fair housing trainer with the Texas Department of Housing and Community Affairs, and he speaks for landlord, tenant, and fair housing seminars quite often. And also, we have attorney Amanda Powell, who is the staff attorney with Lone Star Legal Aid's Equitable Development Initiative. Her work includes eviction defense, litigating various housing related issues such as retaliation and repair and remedy, advising on HUD complaints, and pursuing fair housing discrimination claims. She also advises and assists persons with disabilities and requests for reasonable accommodations. And prior to joining Lone Star Legal Aid, Ms. Powell worked for a plaintiff's firm handling Title III ADA claims. So we have two great attorneys here who do great work every day, and we're excited to hear the information that they have prepared for us. So thank you, both attorneys, Bookstaff, and Powell, for joining us. So let's take a look at what this meeting is going to cover. Ms. Kimmy Johnson will discuss some basic fair housing information, like how to identify or avoid housing discrimination, and how to apply this information to advertising and property policies. Attorney Bookstaff will take about 40 minutes to discuss providing reasonable accommodations and modifications, and how to deal with criminal history for potential applicants. And then we'll take a short break, and then we'll come back from recess, and Attorney Powell will discuss or address fair housing complaints related to familial status, discrimination, and eviction basics. And then she'll also give us some best practices on tenant-landlord relationships. And then again, we'll close with the Q&A, and then some helpful resources to send you guys off with. So we want to take a poll of the audience here, and whether this is your first time or you're seasoned in the housing industry, we want to know if you understand your fair housing responsibilities and how they guide your decision making as a housing professional. So please take some time to answer this poll. One is being, I don't know my fair housing responsibilities. Excuse me, A is I don't know, and all the way to D, I fully understand my fair housing responsibilities and how they should guide my work. I'm looking for the answers as they roll in. We've got a mixed bunch here. About 18% right now say that you don't know, and that is perfectly fine. That is why we're having this training. And about 57% of you guys say you mostly understand, and that's also a good place to be because we want to help inform your decision making as it relates to fair housing. So you can continue to answer that poll as we move through, and then we'll probably close it in a few minutes. So please take note of this disclaimer here. The information that will be provided today does not in any way constitute legal advice, and we are providing informational material only. If you do require legal advice, please contact an attorney for assistance. Some of the questions that you may have may constitute legal or political questions that we will not or cannot answer during the Q&A, but we will try to answer as many questions as we can. And now I would like to welcome our resident Fair Housing Education and Outreach Coordinator, Miss Kimmy Johnson.
Thank you, Kristen. Okay, so let's talk about fair housing and why it is so important. So, the Fair Housing Act was passed in 1968, and it is a civil rights law created to put an end to discriminatory practices in any activities related to housing. And so, the act ensures that every person has the right to rent a home, to purchase a home, or obtain a mortgage without fear of discrimination due to their membership or their perceived membership in a certain class. So, where you live truly matters because housing plays a significant role in determining your quality of life because it directly affects your access to the transportation and the recreation that's in your neighborhood, the housing that's within your budget, your social, cultural, and educational opportunities, as well as where you work, your employment, your medical services, and entertainment opportunities. So here's an example. Children whose families move to neighborhoods with better access to opportunities by the age 13 earned higher future earnings than their peers and had higher college attendance rates. So housing discrimination restricts access to these opportunities. And so fair housing trainings like the one we're doing now are especially important because the majority of fair housing complaints come from rental housing transactions. And of those, the two most reported types of complaints are discrimination based on disability and race. So the Fair Housing Act covers a number of processes around housing and housing transactions, and they include the rental or the sale of housing, any housing services and facilities, advertising, lending and insurance, reasonable accommodations and modifications for people with disabilities and for those with limited English proficiency, as well as protecting residents from harassment and retaliation. So, housing professionals may agree that discrimination towards the protected classes may not generally be as obvious as it was about 50 years ago. However, it's still an ongoing problem. And so, it's important to know the difference between each protected class and ensure that your tenant selection process and overall housing policies do not discriminate based on membership of any of these groups. And so there are seven protected classes. I'm going to cover them just very briefly. The first is race, which is a grouping of individuals that are associated with a racial or an ethnic group. Next is color, which refers to the pigmentation of the skin as an indication of someone's race. Next is national origin, which is the relationship between an individual and a state and refers to a person's ancestry, their birthplace, their ethnic background, or their language. Familial status, which we're going to cover at great lengths today, it protects families with children under the age of 18 from discriminatory action, including couples that are adopting children, any legal guardians of children, foster parents, grandparents who have dependents, and pregnant women. Next is religion, which refers to all aspects of religious belief, observance, and practice. And disability, which includes the physical, cognitive, intellectual, and mental impairments if the impairment substantially limits major life activities. And last but not least is sex. And so last year, HUD announced that it will administer and enforce the Fair Housing Act to prohibit discrimination on the basis of sexual orientation and gender identity under the protected class of sex. So today I covered those very briefly for the sake of time. But if you want more information, please do not hesitate to reach out to our office. Okay, so in Houston, affordable rental housing is a major fair housing concern because Houston is a majority renter city, and over half of Houston renters pay more than 30% of their income in rent. So, breaking it down by income, more than half of renter households who make about $35,000 to $50,000 are cost burdened, and one quarter of renter households who earn between $50,000 to $75,000 are cost burdened. And so we say a family that is cost burdened means that they have fewer financial resources to pay for other things like healthcare, education, or food. So now let's talk about how much it really costs to live in the city of Houston. The minimum hourly wage in Texas is only $7.25, which means that a minimum wage worker would have to work about 115 hours a week to afford this rent, which means they'd have to work about three full time jobs. Houstonians must earn about $21.02 an hour to pay for an average two-bedroom rental home. So, why is this the case? Why are so many families cost burdened? So, according to My Home is Here, a study that was conducted by Harris County and the Kinder Institute with the support of the city of Houston, for those with lower incomes, which is $20,000 or less, there is an affordable home shortage of over 195,000 homes in Harris County. So these renters are being pushed into higher price homes as a direct result of the shortage, but it also pushes them to the next income bracket. People making $20,000 to $50,000 a year to also have to find homes outside of their affordability price ranges due to lack of affordable homes. So, why is this a fair housing concern? Because households are most likely to experience this cost burden in Houston and Harris County are Black, Hispanic, and immigrant households, households with limited English proficiency, and households with children, all of whom are protected classes. So, of those making $20,000 a year or less, 80,000 are people over the age of 60. And so, as we've discussed, people over the age of 60 are much more likely to have one or more disability. So, this shortage is also a disability and an accessibility concern. But to add to all of this, we continue to lose affordable housing stock. In 2020 alone, 13,679 affordable homes for families making $30,000 to $50,000 a year were lost. But another pressing factor that's impacting the protected classes in Houston is the lingering effects of the COVID-19 pandemic. According to My Home is Here, the impacts of COVID-19 on renters of color were extremely disproportionate. When compared to non Hispanic white and Asian households, Hispanic households were three times as likely to have trouble paying for rent as a direct result of the pandemic, and Black households twice as likely to have trouble paying rent. So, according to Understanding Houston, using data coming from public court records collected by January advisors, we also know that during 2020, more than a third of eviction cases were estimated to be filed against Black households, despite the fact that they only make up a quarter of total households. But though many evictions were deferred during the pandemic, we're now beginning to see the result of those financial losses through evictions and household financial stresses. But the current stresses of households of certain protected classes are facing, coupled with the shortage of affordable homes and historic patterns of discrimination, make it critical for landlords and property managers to understand their fair housing responsibilities as well as their staff. So it's important to know how the fair housing laws impact your policies and your daily practices. But by becoming familiar with the following guidelines, you can maintain compliance with the law and conduct your business with fairness. So, this slide is just an illustration of some common discriminatory practices that take place in rental housing transactions. And so, we're going to touch on each one of these in the next few slides. So, here are a few examples of some commonly used statements that may be considered discriminatory. So, such statements may be overt, such as, okay, well, we don't rent to your kind of people. However, more often discrimination is hidden in language like, okay, if I were single like you, I would rent where it's safer, or I don't think you'd be happy in this neighborhood, or would you feel safe living on a busy street like this with young kids? Or even, typically we reserve these first floor units for our tenants with younger kids. So such comments may seem harmless or may come from a place of good intention on the surface, but often this language is used to dissuade certain tenants from inquiring further about a home, and it is illegal. So, advertising, you may be wondering, why are fair housing guidelines for advertising even a thing? But the fact is that if you work in the housing industry, regardless of your position, you're most likely advertising on a daily basis. And so, this is something that HUD takes very seriously. Advertising is the message that you're sending out to the world about the homes that are available and also who's welcome in them. In 2020, there were 327 complaints on discriminatory advertising alone to HUD. But luckily, advertising is easily made equitable, and HUD provides advertising guidelines on compliance for compliance, which we're going to cover on the next two slides. Okay, so advertising under the Fair Housing Act includes anything that you make, you print, or you publish, and that includes things like applications, your brochures, your posters, billboards, or even the pictures that you have in your office. So it also includes such things that you mention about your property over email, on the phone, or in person. So while ads may describe the attributes or the amenities of the property, they should avoid describing the type of person who should reside on the property. So there are certain buzzwords that you should avoid using because they've been associated with discriminatory practices in the past, such as restricted, exclusive, limited, and so forth. So, for instance, you can't advertise that housing is only for a certain racial or ethnic background or exclude families with children with ads that say no children. But your promotional material should also include a variety of the protected classes. So, for instance, just because the neighborhood surrounding your property is made up of residents of a certain background, or the majority of your tenants have a similar background, it doesn't mean that your ad should be limited to just those individuals. So landlords should provide truthful information about the availability, the price, or the amenities and features of a housing unit, and ensure that your policies and procedures are up to date. So the Fair Housing Act itself does not require the use of equal opportunity logo, which you see there in the corner, or the slogan equal housing opportunity in any ad. However, using the logo regularly is good evidence of the company's commitment to fair housing compliance. So it is strongly encouraged. But I also want to mention that this month, HUD issued a new civil rights guidance on marketing and application requirements for subsidized multifamily properties. And that guidance clarifies how certain marketing, rental, and application processing and the waitlist management practices can perpetuate segregation or otherwise discriminate in the violation of the Title VI of the Civil Rights Act. So the guidance is designed to assist property owners to implement more inclusive practices that will be likely to produce discriminatory results. So, in order to read that new Title VI marketing guidance and the implementation sheet, please visit the links in the chat. So, applications and screening. The criteria that's used to determine whether a person is qualified to rent a home should be objective and applied consistently across the board to all home seekers. But it's good practice to have a written policy that contains this criteria. But it may also include occupancy guidelines, availability policy, and an outline of the application process. So, in order to determine if somebody is a qualified applicant, questions may be asked regarding income, employment history, their credit, their criminal background, and their rental history. But it's important to offer those same and conditions to all applicants, which includes deposits or fees, any lease terms, and access to amenities. So to avoid the trouble with fair housing laws, please be sure to be consistent and fair in your screening. So steering under the Fair Housing Act is the process of influencing a home seeker's choice of communities based on their protected class. And so in the rental market, this includes directing particular tenants towards one section of the apartment complex or to a particular floor. Discouraging someone from living in a particular neighborhood by exaggerating the drawbacks or failing to mention amenities can also be considered steering because it limits the housing opportunities that are available to the home seeker. Therefore, it is illegal. So, steering is not just something in the past, but it's definitely a current issue. And in 2019, Newsday, which is a Long Island newspaper, they conducted a study that uncovered evidence of widespread, separate, and unequal treatment of minority homebuyers and minority communities. So, according to the study, 40% of tested housing transactions violated fair housing through steering. So, to avoid steering, it's best to show all available properties to all home seekers and allow that home seeker to make a decision about which property should be viewed or if the property is a better fit for them. But in addition, housing professionals should only present the facts about a property, not about the residents or the neighbors. So home seekers will often inquire about like how's the neighborhood or ask for information about the schools or the crime or the demographics. But you should direct them to reliable resources such as the local school district, the police, or even the Census Bureau to obtain this information. Okay, so now we'll cover property rules and policies. So, with regard to property rules, it is acceptable for landlords to have a set of basic and non discriminatory house rules for all residents to follow. But the rules must be enforced uniformly for all residents, and records regarding rule violations should be kept. All details need to be included in the record, such as the time, the date, the manner of the violation, and how you, the landlord, became aware, and what actions you took to enforce the rules. But access to common areas, including the pool or the gym or the laundry facility, should not be restricted for certain residents, such as children or people with disabilities. So, this is an area where language access can be a problem. And a best practice would be to translate the rules into the tenant's native languages. And don't rely on minor children to communicate property rules to parents. So, housing providers are responsible for the behavior of their staff, and it's recommended that an anti harassment policy be created, distributed, and enforced. So, harassment includes verbal or written comments, any threats, any offers to exchange services for sexual favors, or destruction of property. But tenant on tenant harassment should also be taken serious. And any behavior that violates the resident code of conduct should be documented and appropriately addressed. Staff should respond in a timely manner and have consistently enforced the policy and involve law enforcement or other resources when necessary. And lastly, all employees are required to comply with fair housing laws, including maintenance and office staff. So, fair housing training should be provided for all employees and incorporated into the training process for new employees. Policy should be documented and communicated to all employees and may need to be reviewed on a regular basis. Owners and landlords can be held responsible for the actions of their employees and may be held responsible for their team's discriminatory statements and behavior. So that concludes this portion of the presentation. And at this time, I'm going to turn things back over to Kristen to introduce our special guest.
Thank you, Miss Kimmy. Um, that was a lot of great information about the fundamentals of fair housing and advertising and steering and all of that. So now we're going to take another about 45 minutes for the next segment on reasonable accommodations and modifications, which is most interesting, especially under the Fair Housing Act, and how to deal with criminal history of prospective applicants. And now I'm going to turn things over to our first special guest this afternoon, Howard Bookstaff.
Thanks, Kristen. Hope everyone's having a good afternoon. Next, we're going to talk primarily, well, next slide. First of all, as they said, no legal advice from up here, from this podium. virtual podium. Nothing confidential about anything we're talking about. Trying to give you best food for thought to take back to your properties and consider what we're talking about. Next slide. Kimmy told you that one of the most, I think it was Kimmy or Kristen, one of them told you that the most prevalent types of complaints are race and disability. Well, based on a 2020 annual report from TWC, disability actually had about 62% of the cases, and race was second with about 30-something%. So disability is really the most prevalent now of the types of cases. And I think it's because you're probably able to follow, and you're probably born knowing that you shouldn't discriminate based on some of these protected classes. Disability, though, is very difficult. Well, you're not going to discriminate against somebody because they're in a wheelchair or something. That part's obvious. The problem is the rules with respect to disability fair housing issues are not really all common sense. They're sort of learned, and I'm going to prove it to you in this segment. We're going to first talk. So we spend a lot of time learning about these rules on reasonable accommodations and modifications, including what everybody likes to talk about, which we'll talk about in a second. We spend a lot of time learning about these because they really are something that has to be trained, and you're not just born knowing. So next slide. Before you can give, or somebody is eligible to get an accommodation or modification, there has to be a disability of the person making the request, or on whose behalf they're making the request. There has to be a disability. So it really is important for us to know what is a disability. And I would even ask, I asked the people I do this for to actually commit to memory this first sub-bullet point, because I think that's the key thing with respect to disabilities. Individuals with a physical or mental impairment that substantially limits one or more major life activities. So 3 things in that definition. It's a physical or mental impairment. Handicap and disability are the same. It's just the Fair Housing Act came out. It used the word handicap as the protected class. And more recently, in the last 10, 15 years, HUD has come out and said, well, the politically correct term is disability. So either way, it means the same thing. It is a physical or mental impairment. Because I've heard people say, when I ask them about this, well, handicap is a physical and disability is a mental. No, it's all the same. Physical or mental impairment that substantially limits. So that's part 2, substantially limits. Not sort of limits, not kind of limits, but substantially limits one or more major life activities. So if I'm saying I'm disabled because I have a bad leg and I can't run a marathon, that is not a major life activity. And I'm a runner, so I would even argue that that's probably not a major life activity. So it's got to be a physical or mental impairment substantially limiting one or more major life activities. Then the throw in here to make it even more broad is individuals who are regarded as having such an impairment, individuals with a record of such an impairment. Next slide. Okay, so now we're on to what is a reasonable accommodation. And what HUD tells us in its regulations is a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So what does all that mean? Basically, I look at accommodations. You need 2 things to have a proper accommodation request. You need a policy or practice, and you need a request for an exception to that policy or practice because of somebody's disability. So we've had cases, we do a lot of the grassroots sort of cases where the TWC or HUD is investigating the complaint. And we have a lot of cases where they didn't fix my air conditioning, and I have a breathing disability, and therefore they violated the Fair Housing Act because they didn't grant my reasonable accommodation. Well, what's the exception you're asking for? Yes, the landlord should repair or remedy the condition in the unit, but is it a repair or remedy case, or is it a fair housing case? So to have an accommodation, a proper accommodation request under the Fair Housing Act, you need a policy and you need an exception to the policy. The classic one is what everyone starts talking about, the assistance animals. I want an exception to your deposit and fee requirements. An assistance animal request is a request for a reasonable accommodation. So you have to think of it that way. There's two things you need with accommodation request. Next slide. And this is, and now this we get into the other end, the modification. So accommodations and modifications. A modification is a structural change to existing premises occupied or to be occupied by a person with a disability in order to afford such person full enjoyment of the premises. So different from an accommodation, which is an exception to some policy you have because of a disability, a modification request is a structural change. And next slide. Vitally important that you know the difference in most cases. Some of you may have tax credit properties or home properties, and this doesn't apply to you. But in a conventional property, it's really important to know whether it's a request for an accommodation or a request for a modification. Because the general rule on modifications, again, if you're a tax credit property, do not pay attention to what I'm saying right now. If you're a conventional property, this is for you. The general rule, it is unlawful for a person to refuse to permit at the expense of the handicap. I use handicap because that's what HUD says in its original regs. At the expense of the handicapped person, reasonable modifications of existing premises occupied or to be occupied by the handicapped person if the proposed modification may be necessary to afford the person full enjoyment of the premises. So accommodation is no charge to the person in conventional properties. In conventional properties, a modification is at the expense of the handicapped person. Next slide. Exception, and I talked about tax credit. I'll talk more about tax credit in a second. So if you're subject to the Rehabilitation Act of 1973, which is certain type of housing for disabled people, you don't have that modification. You pay for it. You don't. The owner pays for it, not the resident. But there are certain things, as you see at the bottom of the last bullet point, unless doing so poses an undue financial administrative burden, then you can work with the person and then engage in how can we do something that still accommodates you. Back to the conventional side now, where it is reasonable to do so, the landlord may condition permission for a modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification, reasonable wear and tear accepted. Okay, so if it is a modification that has to be paid, then it has to be paid for by the disabled person in a conventional property, you can actually require that person restore the unit, pay for the restoration of the unit after the tenancy is over, but two conditions have to be present. One, it has to be reasonable, and two, it has to be in the interior of the premises. Again, this is where you're not born knowing this. I don't know why HUD chose the interior. There must have been a reason, but that's what it is. So that's what we have to follow. Now let's visit the tax credit world. You are subject to the TDHCA rules. This is Rule 1.204, which is out of the Texas Administrative Code that you can Google TDHCA Rule 1.204, and you'll eventually get to this point. I put this one up because this is the one that discusses, it says accommodations, but really they include structural changes in this, so that's why it kind of blurs accommodation and modification are pretty much the same under TDHA rules. And it says that what's notable here, and you can Google Rule 1.204 to read it, but the second bullet point, an accommodation must be within a reasonable time, a response to accommodation must be within a reasonable time, not to exceed 14 days. Okay, so, and again, throw in modification because accommodation really is not defined in TDHA jargon as it is in the Fair Housing Act. And so anything, any request because of a disability, modification or accommodation would be, you would want to respond within 14 days. If for some reason you can't, because it's a modification, you're getting bids or something, I would communicate that with the requester. And so, and this says in the third bullet point, second line, the recipient, that's the owner, recipient of the tax credits, must provide and pay for the requested accommodation unless doing so will result in a fundamental alteration in the nature of the program or an undue financial and administrative burden. So again, we go into that idea of if it's too expensive. We don't really get to there in the conventional properties or modifications because it has to be at the expense, or it can be at the expense of the disabled person. We don't really get to having an undue financial administrative burden too much. I guess we could think of situations where that might apply, but if somebody wants, it's a great checks and balances in the conventional properties because you have a four-story apartment community, no elevator, and a person in a wheelchair really likes the balcony look on the four-story. He says, look, as a modification, I want you to build an elevator. I say, well, okay, it's at your expense. What? My expense? Okay. That usually is a good checks and balances. They don't want it anymore if it's at their expense. And if it was a tax credit property, you may have to say, well, it's an undue financial and administrative burden to build an elevator in this community. More on Rule 1.204. And this is, there's a bit of an exception here for properties awarded funds, tax credit funds before 2001. I think we're getting more and more away from that with each passing year. And so this is that property. You can again, Google 1.204 if you have a tax credit property and you're interested in knowing what those rules are, the special rules relating to modifications and accommodations. Next slide. Okay, next slide. We've talked about that. Okay, I'm sorry about the small print here. We wanted to try to scrunch this in all in one slide, but it's pretty important. March 13, 1991 is the magic date here. If you were built for first occupancy after March 13, 1991, your property should have complied with certain design and construction requirements of the Fair Housing Act. Now, those requirements apply to a covered multifamily dwelling. So to back up, if you were built before March 13, 1991, and you occupied the unit before then, this does not apply to you. But like anything else, as time goes on, we're pretty much going to have so much of the inventory in Houston subject to this because a lot of properties now have been built after 91. So some of the older properties still would not have this, but after 91, they should have this. So what is a covered multifamily dwelling? It's all ground floor units and public and common use areas in buildings with 4 or more dwelling units and no elevator. The elevator is important because the second part is all dwelling units, so all ground floor units, if there's no elevator. In other words, they don't require you to put in an elevator to make all units accessible. But they do require that all ground floor units be on an accessible route. Okay? Now, if you have an elevator, it's a game changer because then the second sub-bullet point applies, and it's all dwelling units and public and common use areas with 4 or more dwelling units if there's at least one elevator. Now, what are the features of accessibility that have to be built into the property if you were built for first occupancy after 91? Well, the public and common use areas must be readily accessible to and usable by persons with disabilities. So we have had cases where the barbecue pit is in a grassy area, not able to be accessed by a cement sidewalk. In other words, someone in a wheelchair would have difficulty getting and using the barbecue pit. So that's a consideration. All doors designed to allow passage into and within all premises of covered dwellings must be sufficiently wide to allow passage by persons with disabilities, including persons who use a wheelchair. So let's say you have a one-bedroom unit, and you have a living room, and you have a bedroom, and you have a bathroom between the two, or just a living room leading to a bedroom. But the door is not wide enough to fit a wheelchair. And someone says, well, I want a modification made that you're not a tax credit property. You want a modification made that the door be widened so that a wheelchair can fit through it. Well, is that an accommodation or modification? It's a structural change. So we'll go with modification. Who pays for a modification if it's not a tax credit property? The person making the request. The resident would have to pay for it. But the reason I'm on this subject in this slide, what if the property was built in 1995? Well, since it's on let's say it's on the first floor, you don't have elevators on the first floor, but all doors must have been wide enough to allow passage by someone in a wheelchair. So in other words, you would not be able to charge the person for that modification because that's something that should have been done already when the property was built. If the property was built before 91 and someone in the exact same fact situation, then you would allow the person to pay to make the modification at their expense. So it's really important to know if it's an accommodation or modification. Then it's important to know whether you were built for first occupancy after 91, because it may make a difference in what you can charge for. Then we have all covered dwellings must also have an accessible route into and through the dwelling unit. Light switches, electrical outlets, thermostats, and environmental controls in accessible locations. Reinforcements in bathroom walls to allow later installation of grab bars. Usable kitchens and bathrooms, such as an individual using a wheelchair can maneuver about and use the space. So if you were built after 91 and someone asked for these things because they're not there, I wouldn't charge them for it because you had to do that anyway. Next slide. Revisiting now a little bit of, these are not 1.204 in tax credit, these are other rules, 1.205. It's really 1.207. They changed it. 207 is now the last one, and I'll put that in so the bullet points are correct. And it gives you an idea of what each one covers. And so again, if you're a tax credit property, look at this if you have this issue of modification or accommodation. Next slide. Okay, let's talk about responding to requests, because this is really where you would get a fair housing complaint, most likely, is how you dealt with the request. Next slide. First of all, HUD does not allow you to require that a request for an accommodation be in writing. HUD even suggests it's a good idea to ask for it in writing, and it's a good idea for someone to put it in writing, but you cannot require it in writing. Okay, so what I like to say is you can't require it in writing, but you can certainly require yourself to confirm what their request is in writing. Next slide. So this is just my idea of an outline of how a response to a request would look like. And I did this for really cases where there may be a fair housing complaint, and we wanted to show what we were thinking of when we responded to the request. So if it's a parking space and you're going to grant it, you may not need to do this. It's only in cases where you might anticipate that there might be a fair housing complaint and you want to document what you said. So the way I would outline any response is number one, reiterate your policy. What is your policy? How about we comply with all aspects of the Fair Housing Law? Accordingly, we will make accommodations or permit accommodations or allow you to make modifications at your expense. Reiterate what HUD says you have to do with respect to the modification or accommodation based on what type of request it is. Number two, I'd confirm the request. Again, you can't require that somebody put their request in writing. You can ask them to, but don't deny it if they didn't put it in writing. But you can certainly confirm their request in writing, and I would think you'd want to do this with most requests for modification because you have to confirm what exactly is the resident structurally changing on your property. Number three, respond to the request. And I figure there's three options: grant, deny, or request more information. If you're not going to grant, I would err on the side of not denying. Okay, which leaves us with, if you're not going to grant it, request more information. I think it's fair to tell somebody what problems you've had with their request or what questions you have about their request, and then tell them what further you want. And normally you're going to be limited in what you ask for. Next slide. Back to off of what I think, and this is what HUD thinks. A request for an accommodation or modification allows a housing provider to ask for three things. Number one, and I start with the second line of the bullet point, reliable disability-related information that is necessary to verify that the person meets the Act's definition of a disability. What is that? A physical or mental impairment that substantially limits one or more major life activities. Number two, reliable, starting with the second line again, reliable disability-related information that describes the needed accommodation or modification. This is where you confirm it. And again, if it's an assistance animal, you probably don't need number two because you know what they want. They want Fluffy the Pit Bull to be your assistance animal. And so that's it. Modification, I think it's really important to confirm that you know exactly what they want. And number three, we use in all cases reliable disability-related information that shows the relationship between the person's disability and the need for the requested accommodation or modification. These can be asked, these three things, as long as it is not obvious or known. You do not want to ask someone in a wheelchair to prove they're disabled. You don't have to do that. You will only ask these questions if they're not known or obvious. Again, the most prevalent cases we run into, and even HUD says 60% of all disability complaints are based on assistance animals. So the most likely one there is, even if you know the person's disabled, you may have an issue with why they need 7 cats and their request for 7 cats. What's the relationship between your disability and the need for 7 cats? And so that might be a question you would ask in that. Next slide. Now, request for modification, my response is I go a little bit deeper. I want to outline how the modification will be paid for. Again, if it's not if it's a conventional property, it's going to be paid for at the expense of the disabled person. What does that look like? If you are allowed to, if it's reasonable to do so and it's interior, are you going to require a restoration, a payment to restore the premises back to the way it was? And if so, are you going to require some sort of restoration agreement? I think it's fair to give the person this information from the very first response, and they may be shocked that they have to pay for it. And so this may be the first time they're understanding that. Next slide. Okay, now we get to specifically on assistance animals. I've alluded to those before. And again, assistance animals are, according to HUD, 60% of what the complaints are on disabilities. Next slide. Now, when I'm talking about what HUD says in this portion on assistance animals, I'm referring to a guidance that HUD came out with January 28, 2020. You can actually Google that guidance. And it's good reading as far as knowing what HUD is thinking, it was designed to clarify certain things that that HUD thought were not clear enough in a previous guidance, and it does clarify in certain respects. I think it makes it just as confusing in some other respects. But HUD does break down. HUD says there's two types of assistance animals. One is a service animal, which is a dog. Only a dog can be a service animal under HUD's definition of service animal, and that is individually trained to do work, perform tasks for the benefit of an individual with a disability. Service animals are the ones the vested animals that are trained specifically to do certain things for somebody with a disability. A seeing eye dog, a dog that will warn you on or get medication for seizures, or warn you if there's a seizure going on, alert somebody. A dog that is specifically trained. That's a service animal in HUD's eyes. The next kind of animal HUD refers to as support animals, which is any other animals, trained or untrained. So training for this other type of, and they're both assistance animals, this other type of assistance animals in the support animal group, it's irrelevant whether they're trained, because again, it's trained or untrained. You could have untrained goldfish that, I don't know how you train a goldfish, but you could have untrained animals that are just as support animals as trained animals that are support animals. So in the support animal category, that's where we have most of our issues, not in the service animals, but in the support animals. Next slide. Okay, questions to be asked to determine service animal. And again, this is your vested animal, the one that's really trained. It's got to be a dog. If it's a cat, it can't be a service animal. It can still be a support animal, which means all the rules apply, but it's just not, you can't just say, well, a service animal, you get it, end of story. It's got to be a dog. And if not readily apparent, is the dog required because of a disability? If not readily apparent, what work or task has the animal been trained to perform? If the answer is no or none on either of these, HUD says you go to plan B. You go to the support animal grouping, not a service animal. But again, the reason I say I don't know how useful this is because at the end of the day, it's still, you need a disability and a disability-related need for the dog. It's just that with a service animal, it's easy to say yes because it's a specifically trained animal because of a disability. So really, most of our cases are now going on. Next slide. Most of our cases are with these types of dogs, the support animals. If not readily apparent, does the person have a disability under the Act? We've talked about that. If not readily apparent, does the animal work, perform tasks, provide assistance, and or therapeutic emotional support with respect to an individual's disability? So there's your, do you have a disability under the Act? And there's your, do you have a disability-related need for the animal? Next slide. What information can you request to show a disability? And these are all in that question, do you have a disability under the Act? HUD gives you some guidance. Government determination of disability, if they're receiving disability benefits, Medicare, Social Security, insurance benefits, eligibility for housing, a voucher because of a disability. If the government has already said this person is disabled, you can probably move on to a disability-related need question because they're disabled. And if you don't have the government determination, the typical kind that we don't usually have that, you can get confirmation of a disability from a healthcare professional, they often consist of confirmation from a healthcare professional. This is not an exclusive list. These are ideas HUD gives you, for example, physician, optometrist, psychiatrist, psychologist, physician's assistant, nurse practitioner, or nurse. I've had social workers. We have a varying degree of type of professions that can give verification of a disability-related need for an assistance animal. Next slide. Okay, documentation from the internet is interesting because this really was a point of needed clarification. What about documentation from the internet? Well, HUD, in the first two bullet points, HUD says, what I think the housing provider side appreciates, Some websites sell certificates to anyone who answers certain questions or participates in a short interview and pays a fee. Such documentation from the internet is not by itself sufficient to reliably establish that an individual has a disability or a disability-related need. So we like that from a housing provider standpoint, that they're selling our tune here, selling our song. We appreciate that. It's just by answering a short interview, some questions, and paying a fee should not get you there. Then HUD, though, does recognize that. By contrast, many legitimate healthcare providers deliver services remotely, including over the internet. One reliable form of documentation is a note from a person's healthcare professional that confirms a person's disability or need for an animal when the professional has personal knowledge of the individual. So my takeaway from this is the personal knowledge issue. And that's what I'm looking for in documentation from a healthcare provider. Next slide. Okay, reliable information showing a disability-related need. HUD states that reasonably supporting information often consists of the same thing from the healthcare provider. Information needs to be specific to the individual. So not general to the condition, but specific to the individual. In other words, this is the idea of personal knowledge again. Got to show a connection between the disability and the need for the animal. Next slide. Okay, pushing back, there's a 2017 court case that actually supported a landlord, a housing provider pushing back on some of the letters they got. The letters were from a marriage and family therapist and said vague conclusory remarks like the therapy dog is needed to help the person cope with mental health conditions. The person had a mental illness and had certain limitations. Next slide. Was impaired by her mental illness, and she met the definition of disability under the Fair Housing Act. But the court says the letters identified no activity, no less a major life activity, that the resident claimed to be impaired by her mental illness. The information provided failed to set forth any facts regarding how the condition substantially limits one or more major life activities. So if you're not satisfied, you do have the right to push back. Keep in mind, pushing back, you run the risk of a fair housing complaint. If you push back, if you don't push back, you run the risk of not having really any pet policies anymore. You have to determine where your balance is philosophically as to how hard you push back. But if you're going to push back, you got to be credible. You have to realize, what does yes look like, right? What are we looking for in things? And you can't be specific because you evaluate anything somebody gives you, but you have to then go from there and determine whether it's credible and whether they've answered those questions. Do they have a disability and a disability-related need? Next slide. Moving on from the issue of assistance animals, how does criminal history impact fair housing? Next slide. On April 4th, 2016, HUD came out with a guidance on how the Fair Housing Act standards apply to criminal histories. And essentially, I'm getting short on time, but essentially, what you want to do is look at your criteria, and HUD suggests a couple of things. First of all, HUD suggests look-back periods on types of crimes that you're going to deny someone for, and starting with specifically types of crimes, and then look-back periods for those types of crimes. For example, we don't, and the whole reason for this, and Kimmy touched on this, is if you have a policy that has an adverse impact on a protected class, even if the policy had no discriminatory intent, only discriminatory effect, it could be a violation of the Fair Housing Act. HUD has said that African Americans and Hispanics are more proportionately arrested, convicted, and incarcerated for crimes than their proportionate percentage in the general population. So what that means is, if you have some vague criminal history criteria, like we don't allow anybody convicted of any crime, that could be deemed discriminatory if it has an adverse impact on persons in a protected class, like race or national origin. And so that could be it. So HUD says, while recognizing there's a legitimate reason to have a criminal history criteria, criminal history background checks, you have to determine how can I still meet my concerns with having that in as little or less of discriminatory impact as possible. So HUD says types of crimes and look at types of crimes and look at when those crimes occurred to determine who might be denied for having a criminal record consisting of those crimes. And so that's essentially the criminal history part of this. Next slide. Next slide. We went through that. Next slide. Okay, familial status. Familial status discrimination is, first of all, what is familial status? It's one or more individuals who have not attained the age of 18 years living with a parent or legal guardian. It includes a designee of the parent or legal guardian. It includes women who are pregnant, and they would have familial status. And so you cannot discriminate against a person with that protected class, familial status. Next slide. Okay, HUD came out with, this is all disparate impact rules. We kind of already went through these in the criminal history part. If it actually predictably results in a disparate impact on a group of persons, your practice, or creates, increases, reinforces, or perpetrates segregated housing patterns because of a protected class. Next slide. Okay, disparate impact. We talked about criminal history. It could also affect occupancy policies, rules regarding age restrictions. Next slide. Occupancy policies. HUD has come out with a memorandum. This is a long time ago, 1991. Well, they came out with the actual policy in 2001, but it was from a 1991 memo by the General Counsel of HUD at that time, Frank Keating, and he says that 2 persons per bedroom is a reasonable occupancy policy, but, next slide, a bunch of other factors have to be considered. When you get to reading these factors, you're like, I'm not sure what my policy is to be reasonable. And so what a rule of thumb may be to have 2 people per bedroom, which is what HUD says is reasonable, plus an additional person in the unit to address all these other criteria. And that's something you just have to get with your companies with, whoever you ask, your professionals about what is the risk associated with whatever occupancy policy you would like to have. Okay, more on, again, if a policy has a discriminatory effect, then you have to dig deeper and go, what is your legitimate concern with the policy, and can it be addressed in a less discriminatory manner? For example, next slide. Age restrictions. Okay, age restrictions, very important because, again, that could have a disparate impact on people in a familial status protection. If you have a policy that adversely impacts persons in a familial status situation, in other words, someone under the age of 18 living with a parent or legal guardian, if you don't have a legitimate concern for having that policy. For example, let's talk about the swimming pool. Probably the easiest example. You have a legitimate safety and security concern with limiting people of a certain age from not being in the pool without proper adult supervision. Well, let's say we said no minors could be in the pool without adult supervision, but I have 17-year-old lifeguards. So really, from a security and safety standpoint, a 17-year-old probably can be in there without adult supervision. The Texas Department of Health, interestingly enough, without a fair housing motive, they came up, I don't think anyway, they came up with new signage requirements last year and new swimming pool rules in Texas that say you have to have a sign that says someone under the age of 14 can't be in the pool without adult supervision. So that's what I would suggest using in your swimming pool restriction is the age 14 and mirror what the Texas Department of Health already says. So swimming pool, fitness center, I can also see a legitimate security reason for limiting age in a fitness center. Business center, what's the point? People under the age of 10 can't use the computers without adult supervision or can't use the computers at all. What is your interest there? What is your concern about that? Well, maybe they can't use it. They don't know how to use it correctly. They access inappropriate material. They vandalize the computers. Why not have, you don't want anyone using the computers without knowing how to use them. You don't want anyone getting inappropriate material on the computers. You don't want anyone vandalizing the computer. So you can have a business center restriction without a relevance as to age. Just nobody can do that. General conduct provisions, same thing. We don't want kids playing in the dumpster. Well, you don't want anyone playing in the dumpster. So if you're going to adopt a rule, don't say kids can't play in the dumpsters. Nobody can play in the dumpsters. So that's essentially that. So I would look, as far as a homework assignment, I would look at your current community policies, and I would look at any ones that have the word minor, children, age restrictions, and I would say, okay, what is our legitimate policy here, and can it be expressed in a different way that does not have an age restriction at all? Next slide. With that, I thank you very much for allowing me to participate, and I give it back to Kristen.
All righty, welcome back, everybody. It is now 3:16, and so we're going to get back into this presentation. I want to introduce for you guys Amanda Powell. She is going to discuss fair housing complaints, familial status discrimination, eviction basics, and some tenant-landlord relationships. And so with that, I turn the floor over to Amanda Powell.
Okay, so in this section or this session of the Fair Housing Workshop, we're going to be talking about the Fair Housing Act, and Kimmy has already done a really good job of explaining some of the basics of that law. We're also going to be talking about familiar status discrimination, what landlords should know about fair housing and housing discrimination, some eviction basics, which I'm sure most landlords should know, but there still are errors in that. And so I think this will be a good refresher for both landlords and tenants. And then last, we'll talk about some tips for good landlord-tenant relationships. Next slide. So what is the Fair Housing Act? Kimmy has already explained this, but just to reiterate, it's a federal law. It protects people from discrimination when they're renting or buying a home or even getting a mortgage or seeking housing assistance or basically just engaging in any other housing related activities. So who is protected under the Fair Housing Act laws? This protects a certain class, which includes race, color, national origin, religion, sex, familial status, and disability. Who is subject to the Fair Housing Act laws? So the Fair Housing Act laws are subject by protects people from discrimination by housing providers, such as landlords, real estate companies, other entities, banks, lending institutions, homeowner insurances. And another thing to add is that I don't know if many people know that real estate agents and mortgage lenders and also rental property managers are also subject to the Fair Housing Act. Kimmy also mentioned some examples of housing discrimination, and I'll just reiterate some of those. Refusing to rent or sell a home, refusing to negotiate for housing, making housing unavailable, are some of the examples of what some housing discrimination might look like. Next slide. So we're going to talk about HUD discrimination complaint, how to go about filing a discrimination complaint. So if you happen to be someone who have feels like you've been discriminated against, you can file a HUD complaint. What's most important is the timing. There's time limits. With HUD, you have within 1 year of the incident, so 1 year of when the discrimination occurred, to file a HUD complaint. And you can file it multiple ways. It's very accessible. You can even do it over the phone. You can go online on their website, or you can also send by email. And so this form is really only 2 pages. It's fairly simple. It's not written in a way in which would be intimidating, I think, for um, people who are unfamiliar with fair housing. And so it's pretty simple to fill out, but we here at Lone Star do help with those if you qualify for our assistance. Alternatively, you can file with the Texas Workforce Commission. They have a civil rights division that handle housing complaints, and sometimes they would actually refer um, housing complaints to the Texas Workforce Commission, particularly when there's been discrimination within the state of Texas. Next slide. So what happens after a complaint is filed? Typically, what this will look like is that an intake specialist will contact the person that made the complaint, ask for additional facts about the discrimination. If HUD determines it has jurisdiction, it will investigate. What is meant by jurisdiction here is basically HUD will look over the complaint to make sure that it is housing related. So, for instance, if someone is complaining about repair and remedy issues to HUD, that's not something within their jurisdiction that they would investigate. But um, any of the examples that we discussed earlier, such as a landlord refusing to rent to you because of your race or because you have kids, for instance, that's something that would be within HUD's jurisdiction. If the alleged discrimination occurred within the state, I've said this before, HUD, Fair Housing Assistant Program, will refer the complaint to an agency, someone like Texas Workforce Commission, and that agency must begin the work with the complainant within 30 days, or HUD can take back the complaint. Next slide. So the complaint process, HUD will investigate the complaint. They will interview the person that filed the complaint. They will also interview the person that's been accused of the wrongdoing or the discrimination, any relevant witnesses. The investigator will collect all of the relevant documents and also go to conduct on-site visits. HUD will then to attempt to conciliate or mediate through a mediation process with the parties, and this is completely voluntary. If the conciliation or mediation doesn't work, HUD will finish investigating, and it could either issue a determination of either no reasonable cause and close the case, or determine that there was some reasonable cause and charge the respondent with violating FHA. An appeal or request for reconsideration can be filed. A complainant can also file a civil action in federal court if it disagrees with HUD's decision. Another note I want to add is that you can file a private lawsuit without a HUD complaint, but you have to file it within 2 years of the most recent discrimination that occurred. So you don't have to go through HUD. You can file your own suit if you wish to do that. Next slide. So what happens if HUD finds that discrimination did occur? They'll issue a charge. and it'll go before an administrative judge who will hear the case unless either party chooses that the case be heard in federal court. But the parties must elect within 20 days of receiving the charge. They must elect to have it in federal civil court. If no one decides that they want to be heard in federal civil court, a HUD administrative law judge would hear the case and make an initial decision. And within 15 days of the initial decision, any person that's been adversely affected can petition the Secretary of HUD for review. The Secretary of HUD has 30 days after the initial decision to affirm, modify, or set aside the administrative law judge's initial decision, or they can remand the initial decision for further proceedings. If the Secretary does not take any action within 30 days, the decision will be considered the department's final decision, the department meaning HUD. Next slide. Another thing that I forgot to add to the fair housing, while it does cover most housing, there are some circumstances in which the act might exempt an owner occupied building. Well, an example of that could be an owner occupied building with no more than 4 units and single family housing that's being sold or rented without an agent or a broker. And that's something that you might want to think about as well. Even though the Fair Housing Act is broad, there are some exceptions in which some housing providers might not be subject to the fair housing law. So now we're going to talk about familial status discrimination. Howard went into this towards the end part of his presentation, but it's also under the Fair Housing Act. Housing providers may not discriminate based on familial status. People who would be considered to have protection under familial status would be families with children under the age of 18, pregnant women, any person in the process of securing legal custody of a minor child, that's including adoptive or foster parents, and persons with written permission of the parent or legal guardian. Also do want to add to this that the Fair Housing Act do exempt some senior housing or facilities from the familial status discrimination violation. I know a lot of people, if you have relatives who live in senior housing or senior living facilities, they do have certain policies regarding children. And under those situations, the act or the familial status may not actually be a violation. Next slide. So examples of familial status discrimination might look like refusing to rent to families with children, evicting a family once a child joins the family, requiring families with children to live on specific floors or in specific buildings or areas, imposing overly restrictive rules about children's use of the common areas, such as the pools or the hallways or open spaces, and then advertising that prohibits children. So I've seen some advertising that have blatantly advertised, we're not interested in families, for instance. So if you do feel like if you are under the familial status and you feel like you've been discriminated, again, you can file a HUD complaint through the process that I explained in the earlier slides. Next slide. So what should landlords know about fair housing and discrimination? Lying about or representing the availability of housing when there's actually housing available. This happens a lot. I hear renters and tenants speak about that a lot, requiring different terms or conditions based on the household member's race, color, origin, religion, sex, familiar status, or disability. Advertising that indicates a limitation or preference based on race, color, national origin, religion, sex, familiar status, or disability, refusing to make accommodation for a person with disability, and then also retaliation, which I'll explain further in the next slide. Next slide, please. So what is retaliation? That's when a landlord wrongfully takes adverse actions against a tenant because the tenant tries to exercise some of his or her right. That might look like requesting a reasonable accommodation, for instance, or asking for repairs to be made in the unit or the home. It's presumed that it's presumed retaliation if the landlord makes an adverse action within the 6 months after the tenant has tried to exercise their right. Some examples of what adverse actions might look like is a landlord terminating the lease, filing for an eviction, depriving the tenant of use of the premises, decreasing services to the tenant, and then also I've seen also examples of increasing the rent. Next slide. So an example of retaliation might look like, I think I mentioned this earlier, tenant requesting repairs or even filing a HUD complaint. And then the landlord decides to increase the tenant's rent within that 6-month period after the tenant has filed a HUD complaint, for instance. That would be considered or presumed retaliation. What's not considered retaliation? If a tenant actually does owe rent, for instance, then that may not be retaliation if the non-payment of rent is valid. Next slide. So let's talk about some eviction basics. And I'm sure a lot of you guys may know or not know. And it gets kind of, there are some misconceptions about some, so hopefully this presentation might clear up. So a landlord must provide a tenant a 3-day notice to vacate. And obviously the lease will control in this instance as well. So if there's less time that's provided for in the lease, then the lease will govern. If a tenant does not move out after receiving a notice, the landlord can file an eviction. The landlord must make sure that file the eviction after the expiration of the notice to vacate. So the actual notice to vacate is not the eviction. The eviction can only occur through the court process. So the landlord can't go and throw the tenant's belongings out on the street. The tenant has a right to be there if they choose to contest the eviction. So there is a process. I've seen where landlords, some will file the eviction before the 3-day or whatever number of days that's provided for in the notice to vacate. That's improper. Another thing to know is there must be some breach of the lease. One of the main breaches of lease or causes for eviction is non-payment of rent, but also any provisions of the lease that might be a violation is considered a breach, and so an action may be filed based on that. But it has to be something within or that's a breach of the lease. So if the landlord wants to, for instance, sell the home, they can't just evict the tenant. And we'll talk about further what the process is for if there's holdover or termination of tenancy. Next slide. The notice to vacate, also known as a demand for possession, it must be in writing. So just simply telling the tenant they have to leave is not sufficient. The notice period must comply. as written in the lease, or like I said before, 3 days if there's no provision within the lease. And it does not have to include the reason for eviction, but it's the best practice for the landlord to state the reasons. And we'll talk a little bit later too about why that's important, because we are going to talk about how to have better relationships between landlord and tenants and how that's so important. I also want to note too that federally subsidized tenants and federally subsidized housing, there are strict rules. The federal government or HUD regulations provide greater protection in those instances. And so you do want to make sure that you know what the notice requirements are and what the notice, everything concerning notice and service when it comes to housing, federally subsidized housing. Next slide. So how to serve the notice. And this is a big thing that always comes up. The date on the notice should be the date that the landlord is serving it. So if the date of the notice says Monday, the landlord should serve the notice on Monday, not Friday. That's important to note. And this can be done through personal service on the tenant or service on a member of a household or co-tenant who's at least 16 years of age by registered mail, certified or regular mail, or either posting it to the inside of the front entrance door. I see this come up a lot. Posting it to the outside of the door can be proper, but there's a lot of requirements that you have to meet in order for properly serving the tenant that way. So if you're going to post it to the front door, and typically you would do that if there is no mailbox or if you're unable to enter the tenant's apartment or unit. You have to put the notice in a sealed envelope with the words important document in all caps, and not or, but and the landlord must mail a copy to the tenant on the same day from the same county. Also, another thing to know is the notice period is calculated from the day on which the notice is delivered, not when it's mailed. Next slide. So the petition for the eviction should be filed in the precinct where the property is located. So if the apartment or home is in Harris County, you should file in Harris County and not in, I guess, Waller County, for instance. Tenant will be served with a copy of the citation by the constable. Once the eviction hearing is set, the tenant should go to the court hearing to avoid a default judgment. And this applies to both tenant and landlord. So if the other person doesn't show up, if one person doesn't show up, the other party wins essentially. If the court rules in favor of the landlord, the tenant will be given 5 days to vacate the property or may appeal the court's decision. Next slide. So what can the landlord ask for in a petition? The landlord can ask for rent, and where rent is due and payable monthly, each month's rent actually constitutes a separate and independent cause of action. A landlord may sue for rent, but not other amounts. That also comes up a lot, where I would see landlords put in the petition the rent plus late fees. So the petition should only include the unpaid rent. Counterclaims or joinder of suits against third parties are not permitted. Landlord may also seek attorney fees and possession, which is another important aspect to eviction suit, which is also called a forcible detainer and entry suit. The issue of possession must also be there. Also, if there is an issue as to title, that's not something the justice of the peace court will handle. So, next slide. Non-attorney representation. So, non-lawyers may represent a landlord in eviction in justice court only in cases for non-payment of rent or holding over beyond the rent period. A non-lawyer agent may also request or obtain a default judgment in eviction case in justice court. Next slide. So some common defenses that tenants or renters can have for an eviction might include improper service of notice, and we've talked about what proper service of notice looks like, which is a common mistake that landlords make. Also, the notice being oral and not in writing. The landlord having a habit or policy of accepting late rent and essentially waived going forward with the eviction proceeding. And that's important because Howard talked about keeping consistent policies. Landlords should keep consistent policies. Also, filing the suit before the end of the notice to vacate period, or filing it before for instance, if it's a month-to-month tenancy that you want to terminate, you have to both give the tenant a 30-day notice to vacate. A 30-day termination notice. And after the expiration of the 30-day termination notice, you have to give a 3-day notice to vacate. And then after the 3-day notice period, then you can file. Reasons for an eviction that's not in the rent lease. Again, I mentioned that earlier, evicting for invalid reasons or not legal grounds. Retaliation, and also reasonable accommodation. I haven't had this, but there is law that suggests that if if a tenant who is disabled, for instance, and is receiving Social Security disability later in the month, that it is considered reasonable for that person to make a request, and the landlord should accommodate that request to have the tenant pay later in the month. And so that might become a defense in a situation where the landlord is evicting the tenant for non-payment of rent or because the rent was late. Next slide. So the right to appeal, either party has a right to appeal within 5 days. That 5 days includes weekends and holidays, so please be mindful of that, and it goes by fast. Have to file 5 days from the date of the judgment. Once the appeal is perfected, the justice court judgment is vacated. That means it's void, and a new trial will go up to county court. It's a new trial. If you cannot, or if the tenant cannot afford the appeal bond, they have a right to file the appeal with a pauper's affidavit. If judgment is based on non-payment of rent, the tenant or renter will have 4 days from the date of the filing of the affidavit to deposit 1 month's rent to the court registry. And this is important for tenants to note, renters to note as well, that they have to continue paying the rent into the court registry. Just because it's pending appeal doesn't mean that the tenant doesn't have to pay rent. They have to continue to pay rent, and they have to pay it timely into the court registry. If the tenant or renter do not deposit the rent, a landlord may ask for a writ of possession while the appeal is pending. Next slide. What is the writ of possession? That's when a tenant can only be physically forced out of the property after there's an issuance of a writ of possession. Like I said before, the notice is not a writ of possession. The notice to vacate is not. the judge has to order an eviction, and that's when the landlord actually will have a right to possession. The writ of possession may only be issued after an eviction judgment is final. The justice court judgment is not final until the 6th day after the judgment. The landlord may then ask the court to issue the writ, and it is served by the constable. The tenant and all of the occupants will have 24 hours after the service of the writ to leave the unit. Next slide. Some best practices for good landlord-tenant relationships: always communicate. Um, Obviously, that's the key to any good relationship, is just keeping open communication. A lot of times, what tends to happen is that there's miscommunication, which causes issues, and makes for a very difficult lease term and relationship between both the landlord and tenant. Also, I tell the tenant, make sure that they're familiar with certain terms of the lease, and then also the landlord should be as well. Particularly for the renter, they should know how much their rent is, how long their lease term is, things like that, provisions in the lease that might expound upon repairs and those sorts of things they should be familiar with, and the rental property manager as well. Maintain consistent and accepting application and enforcing rules. Uh, Landlords should do that, and be consistent with all tenants, and not with some, just some. So accepting late payments with some certain tenants and not others. It's just good to be consistent. I do encourage rent communication. But it's also important for landlords to be very flexible and just really work with tenants, particularly those who aren't tech savvy. I know landlords have portals for different stuff, particularly when paying rent, and also with the requesting repairs and that sort of thing. But there are a lot of tenants who are elderly or those who aren't as tech savvy, and they might call to um, decide to request repairs or whatever it might be, or discuss a lease violation, or even wanting to renew the lease. Just make sure that you're being flexible with tenants. That helps a lot. Respond promptly to tenant concerns, and that could even mean, even if you don't have an answer right away, it's just saying, I have received your message, I will get back to you within whatever time frame that might be. Clearly post and consistent, I've said this already, um, enforcing property rules, no selective enforcement. That's when you run into situations where you might be in violation of the Fair Housing Act and subject to someone filing a HUD complaint, for instance. Um, the next tip would be just being open to negotiating if there is a lease violation, or something that comes up. Even if it's non-payment of rent, there's rent relief that's out there. I encourage landlords to participate in that, particularly if the tenant has applied. I think Harris County rent relief um, has money, and it's really good if you can be flexible with the tenant, and so that you can at least get some of the funds that's out there through these rent relief programs. Next slide. Again, my name is Amanda Powell. This was for legal education purposes and not legal advice. Thank you guys so much for your time. You can visit our website, our website here at Lone Star Legal Aid, and you can also email me at apowell@lonestarlegal.org. Again, thank you, Kimmy and Kristen.
Thank you so much. Um, it was a lot of great information. Thank you so much. We are now going to get into our Q&A portion of this segment, we want to take some time to answer a few questions that were submitted. And we just want to highlight that we will only address the fair housing related questions that we received. And so now we're going to open that floor. And as I read the questions aloud, then attorneys, Powell and Book staff, or Kimmy, you can answer the questions accordingly. And I will ask that you guys mute yourself if you're not actively answering a question. And then, of course, you can add to another person's answer. And so we'll start with some questions that were submitted before the event. So my first question is, why is April Fair Housing Month?
That's a great question. April is Fair Housing Month because that is the month that President Johnson signed the Civil Rights Act of 1968. And so that was on April 11th. So that's just been adopted as the month that we observe Fair Housing Month. But we're definitely sure to do it all year long. So that's something that we also encourage.
Absolutely. Good. Thank you. And happy Fair Housing Month again. So another question is, how can a landlord or property manager advertise a rental house to people who qualify for housing programs, i.e. Section 8, without violating the Fair Housing Act? And anybody can take this question.
I'm happy to weigh in. I think the HUD and the Fair Housing Act all accommodate any special needs that your housing has. So if you are, for example, if you are a housing that gets special financing for housing people with disabilities, you can recruit people with disabilities to come to your housing. I would be very factual with respect to what you accept and what you don't accept. Based on your housing, and always get the proper advice from whoever you get advice from regarding those issues, to make sure that, again, you're very factual on what you're doing, so you don't say things. What fair housing doesn't like in advertising is things like we have a really good private school here that's run by the local church. We have a lot of synagogues in our area, so come live here. That they don't like that kind of stuff. But if you're Section 8 and you have special housing for whoever, and it's because of a federal program or a government-run program, I would be very factual about what you have.
Thank you. That's fair. Amanda or Kimmy, do you guys want to add to that? No? Okay, good. So the next question is, what is the most efficient yet proper way to screen potential tenants?
Amanda, no, you don't want to take that.
I think you can handle it better than me.
I mean,
I deal more with tenants and renters, but
there's two things that I would suggest. Number one is make sure Texas does have a law, not a fair housing law, but a Texas property code law that says that you have got to have your rental criteria in writing and made available to people who apply to rent a unit in your community. I would, in light of that, you have to have it in writing. I would make sure that you have a solid rental criteria that, like I talked about criminal history in my thing. That shouldn't be something that you're deciding when person A applies with a certain rental criminal history criteria. It should be something that's in your rental criteria that's already thought about how we're going to, who's eligible for rental here. And so I would have solid rental criteria that, again, you properly have reviewed and make sure it passes fair housing muster, number one. And number two, consistency. I would be very consistent with respect to how you work, how you use that rental criteria to determine eligibility for rental.
Absolutely. I second that. Be consistent across the board with all of your applicants. And Howard, we're missing your lovely face. If you want to be camera on, you can do that now. But we'll move ahead in the questions. The next one is, what kind of restrictions can I put around pets that are not assistance animals?
What kind of, you can't see my face right now because my camera's on.
I can see you now. You're good.
Okay. Okay. So I was worried about my face there. What was the question again? Something about assistance animals.
What kind of restrictions can I put around pets that are not assistance animals?
I mean, it's up to you. You can put the way HUD looks at it is assistance animals are not considered pets. So that's why I don't really have pet policies. I have animal policies, some of which don't apply to assistance animals. So I kind of do the opposite of what the person who's asking the question does. But you can have pet policies, whatever you think is appropriate if it's not applied to assistance animals. Typically, we see obviously deposit requirements, fee requirements. Some folks have additional rent requirements, all fine as pet policies, not as assistance animal policies. Some folks have breed restrictions, and they get the breeds off of the internet. As far as I had somebody last week want to do a breed restriction policy, and they got something from the military as far as breed restrictions they have on their military housing. So they went with that. So you have breed restrictions, you have number restrictions, weight restrictions, and that's pretty much you do. But I would always caution you whenever you're going to do any type of a policy, have a legitimate business reason for the policy that you can articulate. Otherwise, what's the point?
Absolutely. Thank you. I'm going to ask Amanda a couple of questions here. Amanda, can you please repeat some of the information that you discussed about evictions with regard to tenants being month to month?
Sure. So I think the main thing that I mentioned with regard to that is when you're terminating tenancy, you have to follow notice procedure, and that requires basically one looking into the lease because that will govern. But typically 30 days, either party could give 30 days if they choose to terminate the lease. And that's if there is no lease term and the tenant is going month to month. Either party can terminate the lease. That's just a termination notice. Okay, the landlord would give a termination notice, and then after the expiration of whatever the 30 days, for instance, then the landlord must also give a notice to vacate. So what I've seen a lot of times is that being combined. And what should happen is a termination notice followed by a 3-day notice to vacate.
So that's 33 days total, right?
Right. Typically, that's what that would look like.
Okay. And then to follow that up, the notice period for a notice to vacate, can you clarify for our audience if that's 3 calendar days or 3 business days?
So, my understanding is that it is 3. Let's see. No. It's 3 days, not including weekends. Let me make sure I get this right. So I did make a little mark here about it. And then Howard can chime in if he wants to add to that.
Yeah, I think the property code will say that it is calendar days, but if the third day falls on obviously this is going to be obvious, the third day falls on a Saturday, Sunday, or legal holiday. I'm sorry, if the fourth day after the 3 days falls on a Saturday, Sunday, or legal holiday, you won't be able to file the eviction because the court won't be open. So I think it's calendar days, but for example, if you give it if you give 3-day notice on a Wednesday, and I always wait, which is another thing to note, I always wait. If you give it to Wednesday, Thursday, Friday, Saturday is your 3 days. Sunday is your fourth day, but you're not going to find a court that's open on Sunday, so you have to file on Monday. But if you gave it on a Thursday, then it'd be Friday, Saturday, Sunday. You could file on Monday. Hopefully that's clear.
Okay. So I think I probably need to check the code on that, but it's my understanding that it doesn't include the weekends, right? So if the landlord is serving it, for instance, on a Friday, then the landlord has to give the tenant that Monday, Tuesday, and Wednesday. And I will verify that, but there's a lot of different time limits. Like there's time limits for filing. There's time limits for filing an appeal, for instance, which would include if you're appealing, you have 5 days to appeal, and those in that situation would include weekends, for instance. But I think as it pertains to notice to vacate, the weekends would not count.
Okay, great. Thank you both. Very helpful. Here's another question. More HOA neighborhoods seem to be against rental properties in their neighborhoods these days and have created rules that limit the number of rental houses. Is this even legal? And how can HHA or maybe other agencies help the landlord combat these issues and keep Section 8 tenants in place?
Great question. Don't know that there's an easy answer. Not in my backyard, NIMBY we call it, where single-family homeowners don't want apartment communities in their neighborhood because of their concern about a number of things, some legit, some not legit. Like the legit might be additional traffic that will be caused by a larger apartment community going up in a neighborhood. Not legit, I have found not legit, like the Section 8 problem. It's not, a lot of those Section 8 properties are really built well, and they're really nice. They're really nice properties, and the residents are good residents. So, that's just a perception problem that I know we deal with all the time in the legislature, and I know TDHCA deals with it. So it's a problem. Amanda, any thoughts on that issue?
Okay, well, thank you. Thank you, Howard, for that. Let's see here. We only have time for a few more questions. Um, are there any recommended resources for making appropriate and fair lease agreements that you guys can suggest?
I don't sell lease forms, but I think the Texas Apartment Association lease, although it is a landlord-based organization, I think they do go above and beyond. That's why it's such a long lease, to really explain to both parties the different rights and remedies that parties have in a landlord-tenant relationship. There is a lot of things in that lease that wouldn't have to be in the lease, but for they like people have the same rights and remedies whether they're in the lease or not. But it explains a lot of things in there, and I think it's a pretty good lease and fair lease from both perspectives. But read the lease. Obviously, if you're a tenant, read the lease. If you're a landlord, read the lease and make sure that you're happy with what you're saying, and make sure that you know your rights and responsibilities.
I was just going to say, and I will add too, if you're landlord wanting to draft a lease, maybe if you can consult with a lawyer just to make sure it's contractual, fulfilling those requirements for a contract. I know there's, a lot of leases that aren't 100 pages long, for instance, and some landlords are wanting to draft their own lease and it be simple. But I would suggest also you confer with a lawyer just to make sure you're dotting your I's and crossing your T's.
Absolutely. Thank you. Thank you for adding that, Amanda. We'll add one more question here, maybe two more. Can you please briefly restate the pet fees versus the residents' responsibilities with service animals and assistance animals?
Okay, remember, first of all, assistance animals can consist of service animals and support animals. So their service animal is an assistance animal. But as far as the pet fees, an assistance animal fees and deposits would not apply to a qualified assistance animal. When I say a qualified assistance animal, those are the animals that somebody has made a proper request, can be orally, but a request that they have an assistance animal, and they provided the proper information to verify they have a disability under the Fair Housing Act and to verify they have a disability-related need for that animal. Once they do that, the fees and deposits would not apply to them, whether the breed restrictions, number, picking up after, any other rules would depend upon what they have requested as far as the exception to what rule they requested.
Thank you. We'll take one more. Can either of you speak to the fair housing concerns as it relates to getting a lease in a language other than English? Maybe not.
Amanda, I'm waiting. No, you don't want to take that?
I'm waiting on you, Howard.
Anybody?
I don't know any specific rules. I mean, I will say if you qualify for Lone Star Legal Aid Services, we have all type of resources for helping to translate for you or interpret in your own language. I'm not sure in terms of if a landlord, if I understand correctly, making the lease be in the tenant's particular language or native tongue. I don't know if that would be a requirement or.
Yeah, let me weigh in on this. So I don't, there is no requirement that I know of in Texas and even in anywhere else in the United States that requires you to have a lease in a language other than English. But you, especially with, and Amanda, you spoke about LEP, limited English proficiency discrimination. So HUD has come out with a guidance on limited English proficiency, but you cannot discriminate against somebody because of you can't discriminate somebody because they're in a protected class, but they may be in a protected class, or that may be evidence of discrimination if you somehow treated someone differently because of their limited ability to read, write, and speak English. Okay, so what does that tell you? That tells you that although you don't have to, because it would be crazy to say you have to have a lease or your advertisement or your signage in every language imaginable, because especially in Houston, we're a very mixed society, right? We have a bunch of different nationalities in Houston. It's truly a melting pot of all types of nationalities. It'd be virtually impossible to cover Farsi, to cover Mandarin, to cover all these things. You couldn't really do that. So I don't know of a requirement to do that, but somebody could certainly, someone who speaks Spanish and you don't have anybody to help them in Spanish, you have to make them feel comfortable that they can access your services, your lease an apartment, and be comfortable doing that. TAA, the Texas Apartment Association, actually has a Spanish lease, but I believe, I don't speak fluent Spanish, but I believe that Spanish lease, I don't even think it's signed. It says if there's any differences between this lease and the English lease controls, which tells you that there's an effort being made to accommodate people who really can't understand the lease, because you want them, everybody should understand what they're signing, but there's a sensitivity to it. But you cannot, as a landlord, you cannot give up your right to provide notices in English, to provide the lease in English, because then is a notice to vacate somehow invalid if the lease was in Spanish, but yet the notice to vacate was in English. So I would stick to the English language as far as your documents, but at the same time being sensitive to people of different cultures, different national origins, different races that may have a need for assistance. And now we have an iPhone. You're right. The iPhone's terrific in trying to translate certain things. So make people feel comfortable that they can access your services to minimize problems you might have with that issue.
Thank you both. I appreciate you both weighing in on that. Thank you. At this time, we're going to close our Q&A portion, but I want to thank you both, Howard and Amanda, for joining us and giving us your time and giving us this great information. Everybody, if you can, throw in some applause reactions for our hosts. Um, I would like to do that for you all. And of course, thank you again for joining us. And right now, we're going to get into our farewell resources for everybody. Before we let you go, um, we did mostly address fair housing questions, but if you have any landlord or tenant questions that have not been addressed, please call our hotline at 832-394-6200, and the extension is 5, and someone can help address your questions. Also, if you have received, or if you still have fair housing questions that weren't addressed today, but they're not related to landlord or tenant issues, you can get those questions answered by emailing us at fairhousing@houstontx.gov. And also, if you have questions about housing vouchers or Section 8 qualifications or agreements, please call the Houston Housing Authority, and you can call them at 713 260 0500. And as you guys have seen, we've already popped up a poll for you guys. We want to return to the poll that we initially asked you at the beginning of this workshop. Please tell us that you've learned some valuable information. Hopefully, tell us if you still don't understand your fair housing responsibilities as landlords and property managers, or now you feel like you're fully equipped to do the work in this housing industry. Let us know what your thoughts are. Lovely. I see about 83% of you guys are saying that you fully understand. So that makes us happy. And please continue to look out for our workshops, and maybe we can continue to inform your knowledge as it relates to the Fair Housing Act. So, our Fair Housing team has a variety of outreach materials that you can use and share with your communities. We have downloadable fair housing information in 6 different languages on our website. And we also have landlord tenant fair housing and the Fair Housing Hotline that is free to any caller. And that hotline is a great resource, and we want people to know that they can call at any time to have tenant, landlord, or fair housing questions answered. Also, any staff member from our fair housing team is available to give presentations about any fair housing related topics, which includes residents' rights under the Fair Housing Act, tenant and landlord issues, and the fair housing complaint process. And so we're happy to present to any type of audience, including your property management staff. So please email Kimmy Johnson. Her email is on the screen. It's kimmy.johnson@houstontx.gov, or you can call her at 832-394-6355. Now, we also want to let you guys know about these new homes that are coming near the Cityscape and Stella Link area. The city needs your input. HCDD will acquire land near 288 in the East Orem alongside the Cityscape Avenue, and we plan on supporting its development with 240 new single-family homes that will be disaster resilient and energy efficient. And we'll also be transforming over 12 acres of land on Stella Link near South Main and the East Willow Bend Avenue to create another 240 single family homes. And these are affordable mixed income developments that aim to create home ownership opportunities for Houston families. So please tell us how we can best utilize this space for these properties and how we can build homes that meet the community's visions. You can provide your input both in person or virtually. Please visit the housing website for more information and help us spread the word. If you're interested, we can have someone speak at a meeting or a community event. We have tons of flyers and signage, or you can just send us a question to our single family large tract division at hsfdp@houstontx.gov. Also, the Coalition for the Homeless is looking for partners to help end homelessness, providing an opportunity for individuals to obtain housing and create stability through the the Community COVID Housing Program, also known as CHIP. And the CHIP program needs more one-bedroom units to lease individuals. Or leased to those individuals. Property managers will receive rental subsidies or assistance from the program, and some property managers may be eligible to receive landlord incentive fees. So, if you're interested in partnering with this initiative, please contact the CHIP Landlord Engagement Team at I think it's homelesshouston.org, or you can call 832 531 6051. And as we close, please help us to improve this event and others. Likewise, take this feedback survey about this workshop. We've dropped a link in the chat, so please tell us if we've done a good job or how we can improve. And you'll also receive this survey link via email along with our other workshop materials. And please don't forget to request your certificate of attendance by emailing fairhousing@houstontx.gov. And as always, if you haven't already done so, please follow us on Facebook, Instagram, Twitter, and LinkedIn. Hit those like, follow, and subscribe buttons on our platforms. And thanks again. And until next time, stay safe. Thanks.